And welcome back. You're still tuned into 𝗥𝗂𝘀𝗧𝗍 We're Building the Nation, 𝗨𝗨𝗪𝗧. So today we'll have a discussion on workplace rights and responsibilities. So we're delighted to have with us Grant Wilkinson, a committee member of the South African Society for Labour Law and also the director at Kirchmanns Inc, as well as an executive at the Global Business Solutions within South African Society for Labour Law. So Grant brings extensive expertise in navigating the complex landscape of unemployment relations in South Africa, and today we're diving into some of the most pressing labour issues affecting both workers and employers in our country. And importantly, we're also going to separate the facts from the fiction when it comes to the labour law. So like I said, the South African Society for Labour Law basically are the leading authority on labour law matters and has unique insights into the current employment shaping our workplace landscape. So whether you're an employer concerned about compliance, a worker wanting to understand your rights, or simply just interested in the evolution of workplace relations, this conversation is definitely for you. So thank you very much, Grant, for availing yourself to speak to us today. How are you today?
Good. Thanks very much for having me. I appreciate it. All good.
And it's only a pleasure. So, Grant, there's often this confusion about what constitutes for fair dismissals in South Africa. If you can maybe just walk us through what employers frequently get wrong and what the actual requirements are under the Labour Relations Act.
Okay, let's start with the first question. It's what employers get wrong often is inconsistency, where they have a code and for Jack they give a final written warning and for Jason or Jane they give a dismissal, and with no good reason why there's a differentiating factor. So consistency is a big issue. Often employers, when they do mess up, it's an emotional decision as well, and I think they need to be objective in terms of how they do things. The law's quite clear, it's quite simple. Granted, it is tricky and there's a procedure at the moment to follow with regards to dismissals. By the same token, if you follow the rules, good reason to take the action, you should be okay. There's changes happening for small businesses. Keep it on your radar. At the moment, already effective since the beginning of the month, there's been, for smaller businesses, some leniency given in terms of the code of good practice. It's changed to allow smaller businesses to not have to follow a trial-like process. You still have to have a good reason why you dismiss somebody. You can't just tell someone to go away. But at least it alleviates the pressure on smaller businesses. Because you have to find that balance, isn't it, between the employer's rights and responsibilities as well as the employee's rights and responsibilities. So it's interesting, the changes. We have to see how the CSMA and labour courts interpret the amendments. But some positive changes coming to play, and then also coming, not breaking news, I suppose some people do know about it, first or second quarter next year. You should see the finalisation of the changes to the Labour Relations Act and a few other pieces of legislation. There's more changes coming as well in terms of higher earners, etc. Yeah.
And when you do speak about what constitutes firstly as unfair dismissal, are we basically referring back in the day it used to be you get 3 strikes and then you technically get fired, you need to get a verbal, you need to get a written warning, and then you basically get your hearing which determines whether you get fired or not. So does that procedure still apply? And also when it comes to that, on what ground is the employer actually able to say, but we're not going to go according to the Labour Law Acts, what it states, you did something wrong or you stole from the company or you fought on company ground, so it's an instant dismissal?
Look, I think even in the dispensation prior to these amendments, there's never been such a thing as immediate dismissal, instant dismissal. The Labour Relations Act does make provision, and John Grogan captures it in his book, Workplace Law. He indicates, as it's set out in the Labour Relations Act, that under certain circumstances, employers do not have to follow those procedures, they have to colloquialise it. I had a case where I felt I could apply that in Port Elizabeth, now 𝗥𝗶𝗴𝗵𝗴, where the employee killed the chairperson who was the owner of the business by shooting him point blank range when he found him guilty. He wasn't going to file a written warning, but he killed the owner before he could issue the warning. And then the initiator called me and said, Grant, what do we do? The police are here. Do we suspend him, etc.? And my view was, and this was about 2005, my view was that this is probably one of these instances where you don't follow procedure. So go to the Metal Engineering Industry Bargaining Council in Port Elizabeth at the time, win the case at arbitration, because when he got out on bail, the guy still took the company for unfair dismissal to the bargaining council, even though he killed the owner of the business with witnesses. And long story short, we won the case, but then I sent it to Advocate Grogan and said, Advocate Grogan, he's obviously a big whale compared to the amoeba that I am, And I said, I think I found a case that actually can give you an example of where that you don't have to follow procedure. Emailed back a week or two later saying, thanks very much for forwarding it to me, Grant. Unfortunately, I disagree with the Commissioner. I think you're lucky to have won the case because I still think a procedure should have been followed. But he's written tons of textbooks. I still remember as a university student, I think I was at edition 6. Obviously, I'm a wee bit older. I'm 46 now. But yeah, obviously there's always a need to follow a process of sorts. So you're looking at two things for fairness of dismissal. They assess whether there's a good reason for the dismissal, substantive fairness, and then procedural fairness is, have you followed the correct procedure? Now, what these changes are bringing about now, there's still substantive and procedural fairness, but there's an alleviation on certain points. And I know we don't have enough time to unpack all of those, but a big help to smaller businesses saying, we understand that you don't have HR resources as a small business. We understand you can't run a trial-out process. So given your circumstances, if you argue it, as long as you follow a fair hearing, give the person the right to be heard, and there's a good reason for the dismissal, you should be okay. But lots of changes.
Thank you very much, Grant, for that explanation, and that is just insane, and especially based on the example, I would have basically thought it's an instant dismissal when it comes to that. But like you said, we don't have enough time to unpack it completely, so I think a follow-up would be suffice just to bring that or break that up more. But also remote work has transformed our workplaces since the pandemic. Like a lot of companies decided, okay, we're saving on costs for rent and so forth, so it works better if our employees work from home. Like what labor law implications does the organization, your organization, basically believe employers and employees should be aware of when it comes to that, particularly around the working hours and also the safety and the monitoring? Because if you're working from your own comfort place, you tend to work longer, you tend to forget about the time because you don't really check the time. But when you're in a workspace, it's like, oh, it's 5 o'clock, I need to leave.
I think COVID sort of changed the way we look at the workplace. A lot of us have over the years, I take myself and my chairman, my direct report, as an example. He's been in business for more than 30 years and he'd been living out car, aeroplanes, etc. his whole career. I've been in the organization now since 2008, and exactly that. I don't need to have an office. I can be anywhere and work, which is problematic if you don't manage it properly. By the same token, it does give you a little bit of an edge. And so we've worked like that our whole careers, basically. But other people who haven't experienced that, it takes a lot of discipline, I think, from the person to manage that. Because you're at home, you've got lots of distractions, you know. We've got a beagle, and I find my wife gets very distracted because he's so cute. So I'd hate for her to work from home because I suspect she'll be giving the beagle way too much attention if she does. But I look at the workplace and go, we have to have clear remote work policies. What COVID did do is make it quite clear that even if people are working from home, health and safety extends to the home if you're working from home, which opened the door to domestics as well. Health and safety is your problem. If your domestic gets hurt at your house, that's your responsibility.
Okay.
No, as an employer, it's your responsibility. So you're working from home, you have a remote setup, and you've got your studio in your house. You get injured whilst doing your job, you could have a claim, even though they're not near your site. I'm not suggesting you claim
That's
against...
quite interesting.
It's the first time I'm on the station. I don't want them to chase me away. I bear no responsibility for any litigation being taken by colleagues. No, that's the thing. It does become a challenge. So you have to make certain that the workplace, which is their home, that was 2020, is safe for work from home. And often people don't want you in their space, but then they have to give a written statement of, listen, these are the health and safety issues or areas I've got covered. I acknowledge that it's safe for work. I don't need anything else from the company. And I'm happy to say that can't waive your claim, but you give some indemnities for the company. But work from home, there's been interesting case law developments over the last couple of months. And we've actually, as the first case actually hit our courts. What happened was they'd given this lady off to work from home during COVID. And this continued, and the reason for continuing to work from home is she had a kid with, if I remember correctly, I might be wrong, but I think he had autoimmune disease. And the timing was off and very suspicious. I'm trying to summarize a case, but briefly, she had lodged a grievance against the company on a particular day or two or a couple of days later, an instruction is given to return to work, the Friday. The return to work is Monday. She's been working at home since the pandemic started. And her belief is, I've got an expectation I can continue working. And this timing coming after a grievance against the manager who asked her to return to work just looked very suspicious. It looked like it was just payback for the grievance, number one. And number two, the court found that it was unreasonable to expect someone, because you're entitled to ask to come back to work. You as an employee can't refuse that instruction unless there's really terrible working conditions. So they're entitled to do that, but besides the lawfulness of the instruction, you have to look at the reasonableness. And it's not reasonable to tell someone who's been working at home for years, Monday I want you back, and tell them Friday for Monday. And the court found that was unfair. Our first return to work case out, and I think there's going to be quite a few more. I think a lot of companies are saying come back.
Yeah, because you need to consider the person's mental state also, and it is affecting a lot of people's mental state because you're in your own isolated bubble. You don't get to engage with a lot of people, so it takes a toll on you. And speaking about when we do talk about remote working and so forth, like gig work has also been on the rise. Like, how do we navigate the system when it comes to gig working and make more provision for gig workers to get the same compensation that someone will get for remote working or so forth?
Isn't there a question about world peace or something like that? I'm joking. No. Inevitably, gig work's always going to be a question. This is the future of work. This is how workplaces are going to be. People want that flexibility. I know, especially being engaging with other countries, a lot of the other countries are way ahead of us in terms of the gig economy. But also you have the age difference as well. I'm, Gen X, 1979? I think I'm X still. And we're sitting at Z plus, I don't know where we're at the moment.
We must ask the Gen Z. She's sitting right in front of us.
Okay. So, people want different things from work. Whereas with guys like myself, and depending on how you grew up, stuff like job security and my salary, that was good enough for me, But for the younger guys, I'm told, they want that flexibility. Don't worry about giving me like the chairman's son. Don't worry about a policy or something like that. He's in Australia at the moment. Don't worry about giving me extra provident fund and stuff like that. Give me Bitcoin or whatever it is, or reward me in shares. Don't give me other stuff. I'm not worried about getting extra this or extra that. Give me this, that instant gratification, because they're in a different space in terms of what they want. So I think we have to really look at the new world of work, put policies in place, and is our country ready fully for that yet? No, but they are making developments into that. I suspect you're going to have Uber drivers. If you look at the trend in Europe and coming through here, Uber drivers are going to get a lot more recognition as employees rather than contractors, because if you do the Section 200 Capital A test, the test for an employee versus independent contractor, often the Uber drivers actually are employees.
But in the long run, if you do gig work, for instance, you don't get the same compensation like someone else. And a lot of employers are basically taking advantage of that because I hire you for one day or for the rest of the week you're gone. I don't need to pay you if anything basically happens, because earlier you spoke about health and safety. So it basically refers to क़oida. You don't claim for that.
Yeah, I think one has to look at it objectively. I'm open about the fact I represent employers. So that's where I am. But like organizations like SASLAW that I'm a committee member of, they understand that just because the employer rep doesn't mean you're the big bad wolf. And sadly, unfortunately, you carry that tag sometimes as an employer representative. I joke that, and it's actually serious, but in the call center industry in Cape Town, because I chair hearings, I was called the angel of death. And my bag, not the backpack I carry nowadays, but when you're younger, you pull the wheelie bag, and it obviously makes a noise like a whooshing noise. My bag, even, it was quite impressive. My bag got a nickname. My bag's nickname was Creeping Death. So, because you are an employer rep, people often tend to think there's the employer who's a big bad, guy, and then you get the employees, poor vulnerable employees. It's not the case. I think my son summed it up. He asked me once, because he tries to understand when he was younger what I do and stuff like that. And that was challenging. But I think the tipping point for him came when he asked me, Dad, when he was older, he asked me, are you the good guy or the bad guy? I told him it's contextual. It depends who you ask at the end of the day. And I think with that comes the whole thing of there's obligations and rights on both sides of the coin, And if you're engaging on an independent contractor basis, voluntarily, you've done it on your own, and you want to do it because you want to control your time, there's tax benefits as well, then that's a decision you've made. Some guys love being independent contractors. Do you get some employers, and I agree with you, there's some employers who just manipulate the system and want to have people on that type of basis. And if there's no good reason why the person's an independent contractor, and if they actually are an employee, they should be an employee. I'm not defending the indefendable. I'm just saying there's a two-way street. As I told my son, there's no such thing as a good guy or bad guy. There's in the labor market, dealing with human beings at the end of the day. Yeah.
Definitely. Grant, it's such a delight speaking to you, and this has been such a fruitful conversation. Just quickly, when we do speak about discrimination in the workplace, which still remains a very sensitive topic at most companies, if you can maybe just explain what constitute, we've already uncovered unfair dismissal, but also including when it comes to the LGBTIQ plus community, and also highlighting some of the common misconceptions that both the employers and employees hold and should not admit to. Because I don't know if you're familiar with the video that went viral on TikTok a few months ago where an employee basically spoke out about, I think it was a Clicks ad or something like that, but the one person is part of the LGBTIQ plus community, and he basically came for someone on social media and demanded that the person lose their job. And in the light of day, the person actually lost their job because of discriminating against a person that's part of the LGBTIQ plus community.
Yeah, I think inevitably discrimination is a very broad term. And if you think about discrimination, the South African environment has changed quite significantly since 2007. 2007, the code on sexual harassment changed to include same-sex sexual harassment and women sexually harassing men. But it was focusing on sexual harassment. And that change was aligned to the Criminal Procedure Act change, because Criminal Procedure Act previously in a PG audience in the daytime, so I'm cautious to describe it, but it was very descriptive in terms of what constituted rape. I'm not going to go into the detail. We can talk about that offline. But that 2007 change aligned with the change in the Criminal Procedure Act, which is correct. The bad guys the guys who are just committing these atrocities could get away with murder, seeing that it didn't qualify technically as a definition of rape. But a few years ago, the code moved away from sexual harassment to harassment. And harassment's a very broad definition, and it's a form of discrimination. And you have to understand, discrimination, there is such a thing as fair discrimination, which inherent job requirements and affirmative action, right, according to legitimate AA plan. And then harassment, the last couple of years, that has changed quite significantly to the fact that if you disagree with something that your colleague who just walked in said, or perhaps he wasn't supposed to walk in, and you look at him and you roll your eyes at him, congratulations, you have harassed your colleague.
Really?
You see, she's guilty. I'll be a witness. And literally, a deeper conversation legally than that, but technically, are you in the ballpark of harassment? Yes. It's any unwanted conduct which impairs the person's dignity. All right? It's expanded significantly, and it's a tricky laws opened up because we live in a society where you get people who are straight line, flat line, nothing much phases them. And then you get really super sensitive people, who look at them skiff and then there's a problem, So it's about just finding that balancing act. And I think it's important everyone looks after their own rights and interests. With that other case you refer to, sorry, you asked about 3 or 4 questions there, that LGBT, I don't have the exact detail of that case, but any conduct, and this is important for your listeners to remember, even if it's your own time, even if you're not wearing a company T-shirt, it doesn't matter. You say, these influencers, the views expressed here on are not the views of anybody who endorses me and stuff like that. That means nothing. That doesn't give you a disclaimer to say what you want to say, right? That still has an impact on your sponsor or whoever is paying you money to talk on their behalf for another campaign somewhere, right? So my tip for guys is always be careful, especially if you are recognizable, if people can connect you to the organization. Any off-duty misconduct, whether that's off-duty in the sense of you catering at Newlands, it's a Cape Town Stadium, and you go off the rails, or alternatively, if you're online hiding behind your Facebook banner, off-duty misconduct still is misconduct, so please just be careful with that.
And welcome back. You're still tuned into 𝗥𝗂𝘁𝗍𝗶𝗿, we're building the nation, 𝗨𝗪𝗧𝗍𝗍. We are speaking to Grant Wilkinson. He is from the South African Society for Labour Law. So Grant, like I said, this is going to be an extended conversation that needs to happen again because there's so much more. And as you know, when it comes to the misconceptions around labour law, like a lot of people is still basically very unsure. So just in conclusion, how can people reach out to the South African labour law if there's anything that they are facing or they just want clarity around? Does this basically constitute as unfair dismissal, or is this harassment, or maybe they didn't get the outcome when they went to the CCMA and just want to know a little bit more how to navigate the system? How do they go about?
Well, I think Fatima Ruston, she's the lady who put you in touch with me, does a phenomenal job for SASLAW, probably one of the unsung heroes of SASLAW in Cape Town. They start there. Fatima's very amenable to contact, but if you go to the saslaw.org.za website, you'll see Fatima's details there. Just stay in touch with Fatima. She's very great. One of those people, that star player in the industry, and definitely cares about the community. She asked me to mention the fact that there is a program, the NPC program. They have the labor courts, usually Thursdays and Fridays. But again, check their website out. That's if you have a situation where you feel you've had an unfair dismissal case or anything like that, it does allow you to access people and attorneys who do provide services here at the Cape Town Labour Court. Other labour courts around the country, I know she'll mention that, but particularly for Cape Town, the Cape Town Labour Court as well. It's usually Thursday or Friday, but check out the website. Mail her and you can ask the program, because sometimes they do rotate the program, depends on where the court's sitting, etc. And then she did mention that there's a program for learners coming through the system to build their network as well. So there's lots of the stuff on their website, so just liaise with them. And yeah, if you want to get hold of me directly as well, you can visit the easiest one for you, 𝗥𝗶𝗴𝗵𝗁.co.za. There's a lot of free information. My details are on there, and I'm happy to share my details online if you want to as well. Welcome to give me a shot anytime.
Thank you very much, Grant. So again, that website is saslaw.org.za. So that's SASLAW.org.za. And all the information that you inquire would be on their website. So are there any additional words in closing you'd like to leave us with?
Well, I think, thank you for having me. I think it's great that you're doing this for your listenership, and we'll chat offline through how we can assist you further. If your listeners want to, more welcome to check out our website, globalbusiness.co.za, and be in touch with us. We have our annual label update at Crystal Towers next week, Wednesday, and just give us a shout if you're interested and have a look and then take it from there. But good luck to everybody. I think it's important that there are going to be a lot of legislative changes. I did a breakfast talk this morning, and I told the guys there's so much that needs to be covered in terms of what's coming. Keep an eye out. I'd tell your listeners and yourself, just keep an eye out for first, second quarter next year, big changes in the labour relations space, besides the Code of Good Practice now, besides the Employment Equity Act, which you've done already as well, and obviously the parental leave case from the Constitutional Court last week. So that's going to have a massive ramification. So, so keep up to date with labour law. Good luck.
Thank you very much, Grant. So there you have it. That was Grant, and I hope that what we basically spoke to today has opened a lot of doors. Again, if there's any questions that you'd like to know, just reach out to Grant directly, or you can reach out to SASLAW and just query, they will be able to direct you in the right direction. So again, Grant, thank you very much for sharing your expertise, and also thank you for basically breaking up things in simple terms so that our listeners understand and get a clear indication what things basically mean for them forward when referring to the workspace environment.